Welcome once again, BADM 107 students. We have finished the risk management introductory portion of the course. We've looked at the legal systems of Canada. Um, in Chapter 1, we've done Chapter 2 on torts, we've done Chapter 3 on contracts, and now in this video we're going to go into a very long chapter on employment law and risk management. Just before we do, though, I did mention that under the topic of seals, that what we now use today, because no one runs around with their coat of arms on a signet ring and a candle of red wax, we use these little wafers, these little red dots. You just peel one of those off the paper and put it beside your name, and then the document is executed. Also, I should mention the significance of the red, okay? The red is significant because back in the olden days when they first started doing the seals, they didn't have these nice little square wax things that you melted on there. So they looked around for candles. And the easiest place to find candles was in church, but the church candles were white or red. If they took the white wax, it was translucent and the coat of arms wouldn't show up when it was impressed into it. But the red had dye in it, and therefore the coat of arms showed up adequately. And lo and behold, that color came down to modern times, and we use little red seals rather than little blue seals or black seals. I should mention that with respect to seals, anything you do to indicate that you're signing the document under seal will probably be accepted by the courts. For example, if you don't have a little red seal, oh gosh, I left my red seals at home, then what you can do is you can take a red pen and you can write a circle, or you can, write sealed and circle it on the document. But there's a limit to the kinds of things you can do to have the seal become effective, and one of those, of course, is you cannot use your fingerprint or your thumbprint, for example. There's a case where somebody signed the document and put his thumbprint there, and the other side, when it went to court, claimed that putting the thumbprint on there was tantamount to signing under seal, and the court said, no, your fingerprints and your thumbprints are identification. So that would be the same as getting someone to witness your document. So that doesn't work. I do have one funny anecdote which I will tell you, and that is I had a very good client, marketing and advertising law client, who sold his business, and he was going into another private venture with 3 other people. And I incorporated a company for them, and I was doing a shareholders agreement for them. Shareholders agreements have to be signed under seal. Why? Because if you're agreeing at the outset what everybody's going to do in this corporation, nobody's getting consideration. All right? So they have to be signed under seal. I drafted the agreement, gave it to him, and I was teaching one day, and blah, 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 which is pretty much what you're hearing right now. My cell phone went off, and it was my business manager wife, and she said, Cam called, that was the client, and he said he's with the other 3 business people right now. They reviewed the shareholders agreement, and it's acceptable, and they wanted to know if it would be possible to have it copied and sent to them so they could sign it immediately while they were all together. So I told my wife to go in and make 5 copies. Why? Well, 1 for each business person and 1 for the corporation, which is a separate legal entity. And I said, and don't forget to put the seals on. Well, my wife loves seals, but she loves the kind that swim in the water. We used to have a cottage on the Hood Canal down in Washington State, and she used to swim, and the seals would go in and swim all around her, and they'd actually play with her. I'd go in the water, and they're gone. It's because lawyers are associated with sharks, and sharks eat seal. No, I'm just kidding. Anyway, she loves seals. So at Christmas time, I gave her a little sheet like this, but it had little pictures of seals on it. Yeah, you know where I'm going on this, don't you? So because Cam is such a good friend of ours, she thought, well, wouldn't it be funny to put those pictures of seals instead of the red dots? And she did that. And I'm lecturing, blah, 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 blah. My cell phone goes off, and it's Cam, and he's laughing. And he says, got the documents, the seals, that's really funny. I don't know what he's talking about. So I started saying, no, the seals are really necessary. And I start explaining this concept of consideration and everything. And he laughs again. He says, you don't know, do you? And I said, no, what? He said, well, your wife put little pictures of harbor seals on the document. And I went, oh no. I mean, I don't care with Cam, right? You can have a laugh with Cam, but these other three business people don't know me. And so they're thinking, this has got to be one of the weirdest lawyers in the whole world. Anyway, I saved myself because I started explaining to him what I was just talking about, how you can do anything. If you don't have the red seals, you can do anything to indicate your intention to sign under seal. And I said, what could be more appropriate than putting a picture of a seal on there? Well, I don't suppose that really washed. But anyway, I did have a corporate minute book with a shareholders agreement in it, and it's signed under pictures of little harbor seals. All right, that's enough of that. Now we're going to get into employment law, which is slide 123. A little bit of history, of course, and that is at the beginning there was no laws pertaining to employment. Okay, eventually, when employers sued employees or employees sued employers, the courts had to make a decision. Okay, judge made law. So we have this whole body of employment law built up around judicial decisions, and then eventually. If you look at slide 124, the governments began to pass statutes. The Employment Standards Act, the Human Rights Code, Pay Equity Acts, these kinds of things to basically to show them that they're acting on behalf of the employees and protecting their interests so the employees would vote for them in the next election. Anyway, now you have this body of judge-made law and statute law impacting employment relationships. Well, that got even messier. And then slide 125 lists some of those statutes. Okay, there's the Human Rights Act, the Employment Standards Act, WorkSafe BC, which is the Workers' Compensation Act, the Personal Information Protection Act, the Employment Insurance Act. There's all sorts of statutes that impact the employment relationship. And then the employment law got even messier with the development of collective bargaining, which resulted in administrative law, as we've already discussed. So sort of turn of the century England from 1800s to 1900s, workplaces were horrible. Employers were maximizing profit at the expense of the employees. The workstations were terrible. There was poor ventilation. There was poor light. They worked from sunup to sundown. They had to eat at their station. There was no health benefits. It was so bad that people were actually dying at their workstation. So you'd be working away and you'd go, and you'd die. And they would come and they would take your body and they would throw it out the back door. If another employee got up to go and take the body to the spouse, he would immediately be fired. Why? Because they had thousands of people looking for work. It was the change from the agrarian society to the industrial society. So consequently, the workplaces were horrible. People were dying at the workplace. They decided maybe if they could collectively bargain with the employer, they would have more strength. I mean, if I go to the employer and I say, hey, I need a cleaner air, he'd say, you're fired, hire the next guy. But if we all got up and walked out, sure, he could hire these other people, but there'd be this tremendous problem of bringing them in, hiring them, training them, and then beginning to supervise them. So there would be a real loss to the business. Well, the businesses didn't like that, and so what they would do is they would hire thugs. And if I suggested that we, as the employees, form together, unite to argue against the employer, he would have me beaten up, killed, and my body would be lying across the doorstep to the employment place the next day, so that when you came into work, you'd go, Peter wanted to unionize. And they did that. But eventually it still got so bad that people were dying anyway. So they began to form unions. Well, the management would hire thugs to form, like a small army that would then beat up on the unions. And the employers actually went to the government, the Parliament of the United Kingdom, and had a law passed making unions illegal. Okay. The union, you're dying anyway, so they would sort of march on the employer, and then these thugs would come out, and there would be this big battle. And that stopped unionization for a while, but again, there were more employees than there are thugs that are willing to put their lives at risk. So eventually, businesses capitulated. The act in the United Kingdom was repealed, unions became legal, and then we had the start of collective bargaining. And the situation for the employees have improved substantially over the years. Okay, so in the Constitution Act, the Charter of Rights and Freedoms were supposed to have equity before and under the law, and the protection of the benefits of society against, age, religion, creed, and that sort of thing. The interesting thing is the Constitution says here are your rights that are entrenched and guaranteed. But nowhere in the Constitution is there procedural law that allows you to actually use the Constitution to protect your rights. The basis by which you do that are found in the Human Rights Acts. And the Human Rights Code in Section 13, which is on slide 128, outlines the fact that, let me read it. A person must not discriminate against a person regarding employment or any terms thereof based on religion, marital status, political belief, place of origin, age, sexual preference, and that sort of thing. Okay? So now we have these rights protected, and that put businesses into an awkward situation because there are times when you almost have to discriminate for the protection of the workers or for the production of the work. So if I have an accounting firm or a law firm, I cannot say, all right, I've had 3 applicants. I've had a white, a black, and a woman, and I want to hire the white guy, because that would be discrimination. But there are other situations. For example, if I have a restaurant, I'm Japanese and I have a Canadian, and I have a restaurant, and I want a Japanese restaurant. And part of Japanese restaurant is not going and just having Japanese food. It's going to a restaurant that has decor, Japanese decor, and being served by Japanese servers, and eating Japanese food and listening to Japanese music. So I want to hire Japanese servers. Oh, wait, hey, that's against the Human Rights Code. It might not be. All right. If I can establish that having a Japanese server is a bona fide occupational requirement or a bona fide occupational qualification, then I can actually discriminate in those situations. I'm from Vancouver originally, and when I went out to a Japanese restaurant, I wanted the whole Japanese sort of ambience. When I went out to a Greek restaurant, I wanted a Greek atmosphere. I wanted, Greek dancing and the smashing of the glasses on the floor and the Greek music and Greek food. And I moved up to the Sunshine Coast. There was a Japanese restaurant. The only person there that was Japanese was the cook that owned the place. Everyone else was from other nationalities. And the Japanese decor was nice. The food was nice, but it was a little bit of a shift or a segue or something when you have someone come up and say, "Hi, my name's Daryl, and can I be your server?" And so, we still go out to the restaurant, but that Japanese person could have hired Japanese servers, except there weren't sufficient numbers on the coast. Okay, so bona fide occupational requirement. Step 1, the complaint by the person that they've been discriminating against is a prima facie case. So that means you can rebut that presumption, just as we saw with restrictive covenants in purchase and sale contracts or employment contracts. So the business can say, no, it is a bona fide occupational requirement that I hire Japanese servers. The burden then shifts it's a prima facie case that it's discrimination, and then the burden shifts to the employer, who then has to establish that it's a BFOQ. Then the employer must demonstrate it was impossible to accommodate that person in some other way. So if you have an employee and you want to let them go because of a bona fide occupational requirement, they do not have the qualifications. You cannot just let them go. You cannot just dismiss them. What you have to do is look around to see if there's some job that you can actually give them to do. And that comes from a case where an East Indian Canadian sued the Canadian National Railway, because the Canadian National Railway came in with a policy that said everyone had to wear hard hats, for protection. Well, there was one job where the employee walked down beside the rail cars with a hammer, a pinball hammer, and goes bing, bing on the metal wheels. And all of a sudden, when it went boing, they would know that that wheel is cracked and it should be replaced. So bing, 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 boing, replace that wheel, bing, bing. And they said he had to wear a hard hat. Well, he had a turban and he could not wear a hard hat. And so they said, okay, well, it's for your safety. If you don't wear the turban, you're dismissed. Well, he sued them. And the Canadian National Railway, when the burden was shifted to them that it was a bona fide occupational requirement, had a real problem. And that was that to protect his head, like from what? There's nothing that can fall and hit him. And so was it really a bona fide occupational requirement for that particular employee in that particular business? So you may have lots of employees working in enclosed spaces, stacking stuff and having things on shelves, or working, where stuff's moving around, and there could be a possibility of something hitting you on the head. It would be a BFOQ. But for this person, it wasn't. That was the first problem. And then the second problem was, okay, if you really insist that, there's a possibility, remote though it might be, that he could be injured and he should wear the hard hat, but he cannot, then what you do is you look around for a job that you can give him in your organization where the hard hat is not a requirement. And if the employer can demonstrate that, well, the only job where you don't need a hard hat is it would be a managerial position and the person doesn't have the qualifications, and so putting them in there would be a hardship for the company because we'd have to get them educated, then obviously the cost of accommodation is too high, and then they could actually dismiss that employee and let him go. All sorts of problems in this area. Some that I agree with and some that I don't. The federal government came in with regulations about the physical fitness of firefighters that jump out of airplanes with a parachute in the wilderness and fight forest fires. Very, very dangerous job. And they came in with a whole series of physical fitness tests. And there was a woman firefighter who had been employed for a number of years and was doing the job and had no problem with it, did all the physical tests, and there was only one, and I think it was you had to be able to run 5 miles, in a certain time. And she just couldn't do that. So it's not important exactly what test it was, but it was one that, like running. And so they let her go, and she sued, and they got into court, and the judge said it's not adequate to just get a series of physical fitness tests and say, okay, you've got to be able to do those. Those physical fitness tests have to relate to the job, the needs of the job. And they could establish that all the other physical fitness tests, to be able to lift certain weights and things, applied. And then they said, why running 5 miles? Why is that important? You cannot outrun a forest fire, okay? And they could not establish that running 5 miles had any direct bearing on the ability to do the job, so she was reinstated with damages. I agree with that one, okay. But there was one that I disagree with. It's just fraught with pitfalls for employers, okay? To give you some idea of how you can get into hot water over these things, a few years ago I was also teaching a class where I talked about the sections of the Constitution Act of 1982 or 1867, which talked about the rights of Indians. And then I started talking about the Indian Act and how that affected contractual capacity. And I was reported to the dean for using the derogatory term Indian. Pardon me, folks, it says Indians in the Constitution. It's not called the Native Peoples Act, it's called the Indian Act, so I cannot change the law just to comply with political correctness. And when I told that to the dean just said, okay, yeah, forget it. But still, it was irritating that a student took exception to that. He should take exception to the fact that the Native people have not changed those statutes, all right? They cannot even agree on the changing of those statutes to use a different term. So why should I be punished for political correctness when I'm just using a legal term? So anyway, those two scenarios show you how incredibly difficult this area of the Human Rights Code is. For employers, you're sort of like walking through a minefield. You have to be very careful, and it's paramount that if you ever decide to let someone go because they're not complying with a bona fide job qualification, you had better get legal advice on that. You'd better look to see if you can accommodate those people because it's a very difficult area. Okay, moving on. We talk about risk management. This is one area that you do need a lot of risk management. I've just explained with BFOQs that you should make sure you get legal advice. Then you have in the attraction of personnel, another pitfall. So HR management needs to make an assessment to determine its employee needs. And by that I mean the HR manager or the person responsible for hiring should sit down and they should say, okay, what jobs do we need? What ones do we have now? What ones do we need to fill? What jobs will we need in the future to make sure that you can actually that you actually need them, because there's nothing worse than hiring employees and then realizing your staff's too big and then have to get rid of them because then you're into all the pitfalls of dismissal. So the first thing you do is you assess your needs. How do you do that? Well, you have to have a job specification. Okay, so for every person that you plan to hire, you'd better have a job specification, and it's on slide 130. The knowledge, skill, education, experience, and abilities essential for the employee to perform the job. All right, so once you've got the job specification, then you want to develop a job description. And this is what jobs this person is going to perform in the workplace. And when you do that, you do not finish it off by saying, and other tasks to be assigned from time to time. That is a mine that you're going to step on and blow yourself up with. The one situation here is when you have a secretarial staff in your office, don't expect that the secretary will get you a coffee. Oh, darling, give me a cup of coffee, please. 2 cream and 1 sugar. Because it's not part of that job description. A secretarial's duty is not to make coffee for the boss. Okay. Now, I worked in a law firm. I was a partner in that 3-man law firm. We had a reception, 2 legal secretaries, and then the business manager who had no management skill at all. But anyway, so there are three lawyers, and one lawyer had his own legal assistant, and then the other two lawyers, Bob Mackay and I, had a young lady by the name of Allison. And we had a kind of an odd law firm. We dealt with the upper echelon people in all the ad agencies in Vancouver. And it was a very sort of pretentious group, okay? They had big offices, they drove big cars, they belonged to the Terminal City Club or the Vancouver Club. They played golf and they had yachts. And so we actually had offices for the three lawyers that were gargantuan because they expected their lawyers to be as pompous. I don't know whether that's the term. They expected us to have the big offices that they had. And so they also, we'd go over to visit them in their offices. It would be, Darlene, bring us coffee. Maybe it was in their job descriptions. I don't know. But in our office, we didn't have that. And so when we had those clients come, it would be nice to have them bring us coffee, okay, to put on the airs that are so important to our clients. So what I did was, with Allison, every morning I would get into the office really early. I would make the coffee. She would come in. I would bring her coffee every day, okay? If I went for another coffee, I would say, Allison, do you want me to get you a coffee as well? And we did that for quite a while. And then one day I said, Allison, I have Mr. So-and-so of McKim Advertising coming over for a meeting. When he's here, would you mind bringing us coffee, please? And she said, no problem at all. Okay? Had I just one day said, Allison, bring us coffee, it would have been more than within her rights to say, it's not in my job description. Period. Okay? So you put it in the job description, and then when you advertise for personnel, they see the job specifications, they know whether they've got the qualifications, and then they look at the job description. They can say, hey, I'm not bringing anybody coffee. Well, then they don't have to apply for the job. Okay? All right. BC Human Rights Code says in Section 11, a person must not publish or cause to be published an advertisement which also discriminates. All right? So you're preparing this ad and you're sending it out to the newspapers or employment magazines or whatever. You want to make sure the lawyers check that over to make sure that you are complying with the law. So that's the first part, hiring them. Now, when you hire someone, are they an employee? A lot of businesses like to hire and say somebody is an independent contractor. There are advantages. For example, an independent contractor you use when you've got work for them, you don't use them, and when you don't use them, you're not paying them. If you want to let an independent contractor go, you just say, we have no further work for you. You don't have to file WCB premiums for them. You don't have to file EI for them because they're a separate business, okay? So how do you determine whether someone is an independent contractor? One of the easiest ways is to look at the Canada Revenue Agency's bulletins, because they always deal with the taxes for businesses, and they are looking for businesses that say, oh, all my employees are independent contractors, so I don't have to pay EI. All right? So they have this bulletin that lists the factors. Now, you don't have to have all those factors, but you'd have to have a majority of them. They're listed on slide 132, and I'll just quickly read them. They are hired to complete a service for a fee. Okay? So they're not hired at an hourly wage, or they're not hired at an annual salary. Okay? They own their own tools. They control their own hours of work. They control how the work is done, so there's no supervision. There's no tax or government deductions done. They invoice for their services. So if I have 5 employees, at the end of the month, the employees don't keep track of how many hours they worked and then give me an invoice and I pay them, right? We do all that, and then we pay them. But an independent contractor actually has to bill for the work they've done. They pay their own expenses and they assume the risk of profit or loss. My client up north, remember Hans, and the guy that painted his roof with the nasty message? Well, Hans has 3 airplanes and he's a pilot and he flies people around to lakes and everything, but he needs a couple of other pilots. And he had one and he wanted to hire another one, but his wife manager said, let's do it by making him an independent contractor so that he takes care of everything. So Hans got in touch with me and I said, well, okay, let's look at it. Are you going to pay him? Yeah, we'll pay him for the work he does. So that's almost like a service for a fee. Does he own his own tools? No, he'll be flying my plane. Does he control his hours of work? No, I tell him when he has to come to work and when he can go home. How is the work done? Well, I supervise him. Okay, and does he pay his own expenses? Like, when he flies the plane, does he buy the gas? Oh, no, we provide that. And then I said, okay, well, call him an independent contractor. Call him an independent contractor. Call him an independent contractor. It doesn't matter what you do. The government is going to say he is an employee. Okay? So it has to be structured correctly. So what we did was the pilot incorporated a business, okay, and my client leased him an aircraft, okay. So he's paying expenses for the aircraft. He's buying his own fuel. He's flying for Hans when Hans needs him, but he's also free to do other work. And that was probably the kicker there. So I said to Hans, okay, is there other work up there for him? And he said, well, yeah, there's all sorts of work. And so I said, well, all right, like what? And he said, well, every once in a while I'll get a request to fly some oil exploration people up into the Yukon or the Northwest Territories. And I said, oh, okay, well, get him to do that work, okay? Tell that company, no, I cannot do it for you, but here's a fellow that can. He's got his own business, so he's got other clients, okay? And then he would be qualified as an independent contractor. Okay, so that's pretty straightforward. You can set it up that way if you're careful and you're complying with the law. But then things get a little messier because the provincial government particularly wants everybody to be an employee because they think it's the NDP nature. They want to protect all those poor workers that the businesses are just taking advantage of. And so they said, well, sometimes the person will look like an independent contractor, but he's very dependent on the employer. And ergo, in 2018, there started to come out with some case law which said we don't have just employees or independent contractors. We now have this new category in between, and it's called a dependent contractor. And so this is a brand new slide this year. Lucky you. No one else got it. The courts have, and this is slide 133, the courts have created a new category. It was in the Pashy versus MDE Enterprises case, and it says an individual may be determined not to be an employee, but is still entitled to reasonable notice because the worker fails or falls somewhere on the continuum between employee and independent contractor. So they must get notice. Oh, okay, when you get rid of an employee, you have to give them notice in accordance with the Employment Standards Act and the common law. When you get rid of a contractor, independent contractor, no, you don't. You just tell them no more work, right? So they said, okay, in between there's this dependent contractor who must get notice. And then another case went on to say that notice will be less than what an employee would get. Okay, such a worker is entitled to notice, albeit somewhat less than a regular employee. I found out about this. It's funny. The law keeps evolving, and it's very hard for a lawyer like me that's teaching to keep current with everything that's happening, because unless I'm doing some employment law in the marketplace as a practicing lawyer, then I might miss it. And so this was all happening around 2018, and I was unaware of it. However, after I retired, my client up north, Hans, needed someone to do supervisory work, and so this person came and he said, "Yes, I'll do it, but I want to be an independent contractor." That's really important. I want to be an independent contractor. It's not the employer trying to make the person an independent contractor just to reduce the amount of paperwork that they have. He has his own business. He has his own letterhead. He bills for his services, and then eventually he continually screws up on the job. He's supposed to be supervising. He doesn't supervise. One of the cabins is painted incorrectly. He's supposed to be able to tie down the aircraft at the dock, and he fails to do it correctly. He's supposed to be doing work installing a water line into the cabin, and he screws it up. So Hans says, "Okay, that's it. You're gone. We no longer require your services." Well, the independent contractor then sued because he said, "Well, you said I could be the supervisor for the whole next year, and so I'm going to lose $18,000 in wages, and I bought a whole bunch of work clothes." And sued Hans, and so now Hans is doing this court case, and unfortunately I cannot help him, but it strikes me that this person, because I've retired, this person says he's an independent contractor, bills for his services, is no longer required, and is now suing for wages. Well, he doesn't get wages. He's not an employee. He might be entitled to notice if he's determined to be a dependent contractor, but he still doesn't get wages for work not performed. And he went out and bought equipment. Well, he says he's an independent contractor. Well, independent contractors take care of their own expenses. So Hans is fighting that court case. It's a small claims court case, and it may go to trial before this course is finished, but I don't think so. So anyway, I'll update my slides as we go along, but there is this new dependent contractor category, and you should take it under advisement that new concepts that I bring into the course are usually tested on the exams. So slide 133 is incredibly important. All right, now in the HR system in a firm, then after you've advertised and hired for your employee, you have to then go through interviews and a selection process. Here again, you have to be extremely careful as you maneuver through the minefield of the Human Rights Code. Slide 134 makes reference to a lawyer who sued the Law Society. And the upshot of the case is, it arises where an employer adopts a rule or standard which has a discriminatory effect upon a prohibited ground on one of the employees or groups of employees, in that it imposes, because of some special characteristic of the employee or group, obligations, penalties, or restrictions not imposed on other members of the workforce. Okay, so this is not a bona fide occupational requirement for a group of employees. This is something internal which is detrimental to the one employee or a couple of employees out of a group. The risk management practice that you should consider putting into effect when you are interviewing and selecting employees is outlined on slide 135, things that you can and cannot ask during an interview. Okay, any questions with respect to race, color, ancestry, place of origin? Absolutely verboten. Political belief? Nope. Religion? Nope. Marital status and family status? That's one, by the way, not two for exam purposes. Nope. Physical or mental disabilities? Nope. Sex? No. Sexual orientation? No. Age? No. Criminal or summary conviction? No. Education? Yes. Oh, well, okay. You can still ask questions about a person's education, provided it goes to the ability to do the job. So there are a whole group of questions that you cannot ask. There may be bona fide occupational requirements that necessitate a selection of one person over another based on something. So, for example, the Conservative Party of Canada needed to hire a political analyst. And a person applied for the job, and he was not a member of the Conservative Party of Canada. Well, this is a very political job. This is a very confidential job, and so they said, no, we would like the person to be a member of the party, and that person said, I've been discriminated on the basis of my political belief, and the court said, no, that's a BFOQ. One of the churches got into trouble because they wanted to hire an accountant, and they said, well, I can't remember what church, but let's say it's the Roman Catholic Church, and they said, and the person that applies has to be a member of the Roman Catholic Church. Well, what does an accountant's job have to do with religion? On the dollar bill in the United States, it says, "In God we trust." That's about the closest connection, okay? So there's no connection between being an accountant and doing the work, or being a Roman Catholic accountant and doing the work. And so that was a discrimination. Religious schools have to walk a very tight line here too, because if they hire a math teacher and they want that math teacher to be a member of a certain religion, well, what's math got to do with religion? However, if they hire a teacher to teach religious studies, obviously it may be a bona fide job qualification that they be a member of a certain religion. So there's all sorts of problems built in there. My niece had an interesting experience. She's now a senior employee with the Ports Canada. But she was working in an HR position, a very minor one, and the federal government created airport authorities. Okay, so one of the easiest ways to reduce the number of government employees so that you're looking good, yes, we've reduced the size of the civil service to save money, is to spin off some government function into a crown corporation, which then isn't accounted, right? So they spin off the airports, and it looks like, wow, they're doing a really good job at reducing the size of the civil service. They're still paying for them. But that's politics. Anyway, the Vancouver Airport Authority was now looking to hire an HR manager. Why? Well, when those employees were part of the civil service, there was an HR department for the government that dealt with that. But when the airport authorities got spun off, suddenly this HR management for the government couldn't be doing that, right? So they had to have their own HR department, and they appoint a very capable woman, well, capable of marketing maybe. She was a senior marketing person, and they said, how would you like to be HR manager? And she said, sure. She knew nothing about HR management. She was a great marketer. So she's starting to interview people for her staff, and she interviewed my niece and asked her about her, her marital status. Did she plan to have a family? Asked her age, and something else. I can't remember which one it was. Anyway, those are inappropriate questions, and they're coming from a person that's an HR manager for an airport authority, which is huge. So rather than just say, hey, you can't ask me those questions, which means you probably won't get hired and you will not be able to prove you were discriminated against, she turned it back and suggested to this woman that she might want to be careful with future applicants. It didn't bother her, but future applicants she might want to be careful with because these were inappropriate and prohibited questions. And the woman was aghast, like, like, really? She didn't know about the human rights code, the federal code. And so she immediately hired my niece because she needed somebody on her staff that knew something about HR management. So you have to be careful about those. Both sides. If you're an employer, you don't ask them. If you're an employee and they do ask them, how do you handle them? And that happened to me as well. Before I became an associate with that three-man partnership that I eventually became a partner with, I was looking for a job, and there was a very large law firm in Vancouver that was looking for an associate, and I applied for it, and another friend of mine applied for it, and I don't know how many people applied, but we were the last two. We were the short list. And I remember they took me out to lunch. I went to a job interview in the morning, which after my interview, this was a second interview, and they asked me, they gave me a scenario and gave me a dictaphone, and they said, dictate a statement of claim for this, and dictate a notice of motion for that, and write a memo on this. And it was very intense, and I was exhausted by 12 o'clock. And they said, okay, now we'd like to take you out to lunch. Well, 4 partners in that firm. I mean, they had probably 68 partners. 4 partners take me out to lunch. And we're walking out to lunch, and casually they said, Holden, is that Germanic? And I thought, oh, bingo, inappropriate question. But I didn't care. And so I said, no, it's English, but I am actually English, Irish, and French. And because those groups over history have always been fighting with each other, it's a perfect background for a lawyer because I can argue from any perspective. Ha, 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 right? A little while later, they said, well, you're older than our other applicants have been. How come? Well, it was because they all graduated from high school, got their undergrad degree, went into law, and then were applying, whereas I had, also gotten an MBA and I'd worked for 5 years. Well, you're not supposed to ask age-related questions, so bingo, that was the second one, but I didn't care. I handled it. And there was another, political belief. I had been in Ottawa and I'd worked for a political party, and so they asked me which party it was, and I know exactly why they were asking it. And to show you that this isn't just casual conversation. So, what do you think about the BC Lions? No, this went right to the job because they want to hire people that have political connections because then they have access to the halls of power, right? Anyway, again, it was a totally inappropriate question. Let me see if there's something else. Physical religion. Oh yeah, when I told them they were Irish, they asked me, "Oh, are you Catholic then?" Is that important to the job? And I'm sure that had I complained, they would have tried to argue that these questions were not job related, that this was just, hey, you're applying to this, let's all go to lunch, have a good time. But the lunch was part of the application process. Otherwise, 4 partners would not have taken me out. They wanted to see if at the lunch I drank too much and passed out in my soup, or whether I'd pick up my fork and scratch my glass eye with it. Just kidding, I don't have a glass eye. But anyway, they were looking to see if I had manners. Okay. So it's very much part of the job application, and they asked for an inappropriate question. And these are senior partners with a law firm. So if they can make the mistakes, businesses out there can. Okay, so you have to be careful about the questions you ask during a job interview, and of course there's quite a number of those, and that would make a very good Part B exam question. Slide 136 is once you've hired them, the next risk management thing you should do is make sure that you have a written contract with them. There are two types of employments. There are term contracts and there are contracts of indefinite hire. A term contract is you hire an employee for a year. One day before the end of the year, do you have to say your contract is coming to an end? No. After 1 year, it automatically comes to an end, so no notice is required. All right. So that's the first one. And then the second type is contract of indefinite hire. This is when you hire an employee and you shake hands and you put them to work and they work for you until age 70, and then you give them a gold watch and they go home after retiring and they pass away. Those kinds of jobs are few and far between nowadays. Most people change jobs numerous times during their career, but it used to be that you got a job and you stayed there until you were 65 and then you would retire. So in contracts of indefinite hire, when does the contract come to an end? Well, there has to be notice. And this is where things get a little awkward. So the risk management process is you want to make sure you have a contract in writing that it covers compensation, wages or salary, and that there's a confidentiality and restrictive covenant. And then you want to make sure that in that contract of employment you list two things: job specifications and job description. Okay. So somebody said, yes, I know a great deal about computers. And then they walk into their office and they sit down and they look at the little overhead projector machine and they go, whoa, boy, I haven't seen a computer like that before. Or they walk in, they sit down and they go, okay, computer, how do you turn this on? Obviously, they don't have computer training, and you can actually dismiss that employee because they've breached their contract. Job description, you want them to know exactly what you're going to do. Now, let's say you want someone to work on payroll, and then eventually have them work on the year-end financial statements. You can say that for the first year and after a certain amount of training, you'll be doing payroll, and then you will be phased in and do the financial statements. But you cannot start off by saying your job is to do payroll and then say, okay, Bill, now you're going to start doing financial services, because they can legitimately say, no, that's not part of my job. And you say, well, it's what we want you to do now, and if you don't, we'll fire you, because that will be wrongful dismissal. Okay, so you want to make sure you have that contract of employment. Training and orientation and supervision are incredibly important. We talked about how poor hiring, poor training, and poor supervision got Tilden Rent-A-Car into difficulties with a couple of court cases. Well, okay. Make sure that on slide 137, we got the risk management practice. Orientation and training should be done. There should be the job description. There should be the job specifications. And there should be occupational health and safety built into it, and an evaluation process so that they know beforehand that after a certain period of time they're going to be evaluated, and they will be required to sign a memo acknowledging that they were evaluated, not agreeing with the evaluation necessarily, but at least acknowledging that it took place. Okay, so introduction of new policies. There's a concept in contracts that I do not remember covering. Past consideration. I'm going to have to check into that, and I may have to fill in that blank. I'll go back and do that afterwards. But if I enter into a contract with you and I'm paying you a certain amount of money to do a certain number of work, and then I come and I ask you to do something else as part of your job, you cannot do that, because you have a contract to perform certain work. If they add other work, then what they're doing is unilaterally changing the terms of your employment. And they say, oh, no, because we hired you and we're paying you, that's the consideration for doing this. Cannot do that because that's past consideration. That's consideration that relates to your duties at the beginning. That cannot be used as new consideration now. And I'm pretty sure that was not covered in contracts, so I'm going to have to go back and fill in the blanks. All right, so you have training, orientation, and supervision for two reasons. Number one is it is important for you to be able to establish a record of what you've done for the employee, in case you have to let them go. The other thing is it's for the benefit of the employee, because getting rid of and hiring new employees is an incredibly expensive prospect for a business. Our law firm, McKay, Turlock and Holden, had a really terrible manager whose only credentials was that she was the wife of the husband of the senior partner's best friend. She had no management training. And we had a revolving door. People were quitting. We had to let people go. We were hiring new people all the time. And it was a very expensive proposition for a small business. So you want to make sure that the employees not only get the training and supervision they need, but they also feel like part of the business. I had a really close friend for years and years and years and years who worked for a company. I don't even know if it's still in existence, so I better not use its name, but he was a journeyman electrician, and they hired him at a plant, and he worked there for 2 years. And then they came to him and they said, okay, Ian, starting on Monday, we want you to go to our other plant. He said, what other plant? They had 2 plants, and he worked there for 2 years and didn't know that the company had another plant. Like, how does that make you feel? It's like, we have a secret plant that we don't. Anyway, you should just make sure that you have training or orientation and supervision. We're going to get into the topic of notice of termination and pay in lieu of notice, and that is quite a long topic, and I'm just trying to decide whether or not we'll do that right here or whether we will do that in the next video. I think we should carry on for a few minutes here. Okay, so we've done training and orientation. Now we're getting into a situation where you want to get rid of an employee. Okay? Now you're not firing him because he's inadequate or misconduct or something. This is a situation where you suddenly realize with the COVID-19 problem, you have to have distancing between people in your workstation. You're not going to have quite the demand for your product, and suddenly you have 28 workers, and you're probably only going to need half of that. Okay, so you want to let 14 go. Well, how do you do that? COVID-19 or not, you are required to either give them notice or payment in lieu of notice. Okay, so if they're a term contract, which is in slide 138, that means no notice is required to let them go. But if you have a 2-year term contract, the difficulty you have is that you cannot just let them go because you're breaching your contract. You would have to pay out their contract. All right, if there's 3 months left on the contract, you might just say, okay, it would be far better for us to just pay this guy 3 months and say, thank you, your job's over. But if there's 1 year and 8 months left, then you'd better have in that written contract a clause that says we can let you go on 30 days notice or 2 months notice or something like that. Otherwise, you have to pay them out. Okay? But in a contract of indefinite hire, where there is no such clause, how do you get rid of them? Well, the first thing you do is you say, okay, are they management or are they just an employee? Okay, a line worker or a staff worker. And the reason here is that 2 factors come into play here: the Employment Standards Act and the common law. So the Employment Standards Act is an act passed by the provincial government that says if they've worked here for a certain period of time, they get a certain amount of notice. And this is primarily directed at regular employees, line workers, secretarial staff, admin staff, rather than managerial. All right? And we'll go through how much notice you get under the Employment Standards Act. But before we get there, the reason I said you have to look at them. So you're a janitor with my business, and you've been there for 4 years. Under the Employment Standards Act, we'll find out that I have to provide you 4 months' pay in lieu of notice, or give you 4 weeks' notice that your job's coming to an end. But if you are the manager of the production group, then and you've been there for 4 years, the Employment Standards Act says you get 4 months or 4 weeks' pay, right? But the common law, judge-made law, because they both have a bearing on this, judge-made law, the courts take the attitude that certain positions may require more notice than that prescribed by statute. For our purposes, we're going to take a rule of thumb that if you are a professional, you get 1 month per year of service. If you're a manager in a business, manager of marketing, manager of operations, you get 1 month per year of service. If you're an accountant, you get 1 month per year of service. If you're a professor, you get 1 month every year of service. In actual fact, it varies between industries. And because I do not practice and did not practice employment law on a regular basis, I'm not familiar with how much each industry requires. But the general rule, and this is the rule that applies, the general rule is 1 month notice per year of service. So my manager of my production group that was there for 4 years, if I want to let him go, then I have to give him 4 months pay in lieu of notice, or I have to tell him or her that in 4 months the job is coming to an end. All right, under the Employment Standards Act, I'm just going to read this because it's technical, and if this is on the exam, I'll probably give you a copy of the Employment Standards Act. After 3 consecutive months of employment, the employer becomes liable to pay an employee an amount equal to 1 week's wages as compensation for the length of service. So for 3 months, you're on probation. The statute does not say you're on probation, but it says after 3 months, I have to give you 1 month's or 1 week's pay in lieu of notice. So I'm paying you for the work you're performing, but I can say, okay, we no longer require your services because you don't fit into the business culture, and then you go. And you go, hey, wait, I need some notice. No, you do not get notice. However, if you are there for 4 months, then I have to provide you 1 week's notice, right? And then after 12 consecutive months, I have to give you 2 weeks' notice. And if you're there for 3 years, I have to give you 3 weeks, 4 years, 4 weeks, 5 years, 5 weeks, 6 years, 6 weeks, 7 years, 7 weeks, 8 years, 8 weeks, 9 years, 8 weeks, 10 years, 8 weeks, 12 years, 8 weeks, 472 years, 8 weeks, 3 centuries, 8 weeks. Okay, I'm being facetious. To emphasize, though, that the maximum amount of notice that you are entitled under the Employment Standards Act is 8 weeks' notice. You may get other notice, but you'd have to sue, and you'd have to establish that there's some particular factor that should be taken into account. But that's the Employment Standards Act. That's the rule. That's what happens most often. If they're there after 8 weeks, or pardon me, 8 years, they get 8 weeks. If it's 10 years, they get 8 weeks. Bingo. And then there's a whole bunch of cases that talk about the common law sort of aspect, that there may be situations where more notice is required. There's the Lazarowitz-Orenda Engines case. This is from 1960. It's a Supreme Court of Canada case, and it's old, so it's not applicable. No, it's still very much applicable. What happened in that case was a BC business was being put together, and it was really just a shell. It was a promotion on our stock exchange, which at that time was called a penny ante stock because it was for promoters to basically take advantage of business people. It's now been cleaned up and it's a reputable stock exchange, but back then it was just terrible. This Orenda Engines company was being touted as a stock that's going to go through the roof and you should be investing, and what they really needed was a person that was going to be the president of the CEO of this company that was really well known in the industry, and would make this sound like a good deal. They made small gas engines, so for lawnmowers and leaf blowers and things like that. There was a company in Manitoba that did that, and the president of that company was well known and well liked in the industry, and so they asked him, "Hey, come on out and be the president and CEO of this company, and we'll pay you way more money." And he said, "Oh, I don't know." He said, "I've been with this firm Manitoba for 22 years, and to go with a startup, I mean, what if it fails?" And they go, "Oh no, man, this is a good company. It's going to be around for years and years and years. This will be the pinnacle of your career. It's just a wonderful opportunity." So he gives the notice that he had to give at that place, and he comes out and becomes the CEO of this company. The stock is launched on the stock exchange. The value of the shares shoot through the roof. All the promoters blow out their shares. Okay, they take shares in lieu of pay for doing all the work to get this going, and then the second that the shares go up in value, because they got them for nothing, they sell them and they get a big whack of money. Everybody sees the shares being sold, and everybody sells their shares, and the company collapses. Okay. Well, he goes in and he says, "Okay, I am entitled to notice." And they go, "Oh, yeah, but you haven't even been here a year, so I tell you what, we'll give you 1 month's pay." And he's astounded. So he sues the company. It goes to the Supreme Court of Canada, who says, "Well, okay, there was a negligent misrepresentation here." They didn't say it was fraud, but it was close to. Negligent misrepresentation here, and so that's a tort, and he should receive compensation. The company cannot pay the compensation because it's insolvent, but the person who makes the negligent misrepresentation is liable. And so they looked at the promoters who had actually made the misrepresentation, who had then blown out their shares and gotten all this money, and they said, "You have to pay." And so what did Lazarowitz get? Lazarowitz got 22 months pay in lieu of notice to reflect the 22 years that he'd worked at his previous job. And so this became a rule that if you were enticed away from another company and promised long-term employment and better pay and everything, and it doesn't happen, then you may be entitled to notice commensurate with how long you worked at the previous business, not just how long you worked with Orenda Engines. All right, another Supreme Court of Canada case, a little more recent, 1997, Wallace versus the United Grain Growers Limited. As you go across the prairies, if you have, you see these grain elevators, and they'll have a big thing on it, United Grain Growers. And that's the company. And they have this fellow Wallace who is the president, and they want to let him go. And it's not really clear why. But they give him the right notice. So let's say he's been there for 11 years. They give him 11 months notice. So far, so good, right? But when people would come and say, "Why did you let Wallace go?" They'd go, "Well, we cannot prove anything, but we think something inappropriate was going on there." You cannot do that. Okay, it's as simple as that. You let someone go, you give them pay in lieu of notice, or you give them notice, but then you don't say, "Well, we actually had reason to let him go." If you have reason to let him go, you have to fire him for misconduct or something. And so Wallace versus United Grain Growers Association stands for the proposition that bad faith conduct in the manner of dismissal is another factor that is properly compensated by additional money to the notice amount. Okay. So they're not giving you 1 month's, pay. They're just saying a lump sum. This would actually be considered to be, if you go back to the tort chapter, it would have to be considered, a penalty. All right. Pecuniary, oh gosh, I can't remember the term. This is irritating. But it's when you punish somebody by making them pay more in damages. Punitive and exemplary. Takes a while for the old gray cell story. Punitive and exemplary damages. But they don't call it that. Okay. They just say it is an amount in addition to what is required. Okay, so far so good. You can really understand those two cases. The next case I have a little bit of difficulty with and really can't understand yet how it's going to impact the employment situation. And there has been, very few cases where it's been talked about. All right, it's Byers versus the City of Prince George. And it says you must look at the prospects of the dismissed employee in finding work. All right, so what happened here? Mrs. Byers, or Ms. Byers, I can't remember whether she's married or not, Ms. Byers, worked for the City of Prince George, and she was in the little booth at their parking lot. People would get into the parking lot, they would pay some money, she would give them a ticket, they'd drive out, she'd get the ticket, make sure they've paid. And that's what she did. And she did that for, I think, 9 years. And then the City of Prince George says, we're paying her a lot of money. We could buy a machine that would do that and save taxpayers' money. So they give her notice. Now, she'd actually worked there for 8 years. So she's entitled to how much? 8 weeks. Okay? So they say, okay, well, gosh, she was a good employee, so let's give her 9 weeks notice. So they're going to give her a little extra money. So they let her go and she sues. They gave her a glowing letter of recommendation too. And she sued and she argued that because that's all she'd done and she had no ability to go out in any other job and those jobs aren't available, that she should receive more money. And it went to trial, and then it got up to the Court of Appeal, 3 judges in BC. And the judges said because she was unemployable and had done nothing to improve her skills during her time of employment, the employer should give her more money. On what planet, in what universe does that make sense? I have 2 employees. Okay, one employee does the routine job every day and does it very well. The other employee does the routine job every day and does it very well. All right. Now, this employee is unsatisfied with the routine job. And so that employee goes out and takes courses in the evening, computer skills, management courses, some technical training or something to upgrade their skills, right? This employee does absolutely nothing except a good job. Now, I have to let them go. They've both been with me for 13 years. Under the Employment Standards Act, they are entitled to 8 weeks and 8 weeks. So I can give this fellow 8 weeks because they have done something to improve their skills and ability to find another job. This person who has done nothing to improve themselves, I have to give them more. That doesn't seem fair. Okay? So just on the basis that somebody improves their skills and you have to let them go, they get more than the person who actually worked hard, improved their skills, and you have to let them go. The other reason it doesn't make sense is under the Personal Information Protection Act, which we talked about at the beginning of the chapter, under those statutes that get passed by the government to make it look, so we're on slide 125, statutes that pass by the government to protect people, workers, right? The Personal Information Protection Act. what's the Personal Information Protection Act says? It says you are entitled to gather information from your employees that help you better manage, paying them wages and everything like that, and other services, health care and stuff. And you can gather information on your customers that help you meet their marketing needs better. But you have to keep that information secret, safe. And when you no longer require it, you have to dispense with it safely. You have to shred it. You have to, wipe the hard drive, whatever. So there's a statute that says you can only collect information that you need. So I come to you as an employee and I say, okay, Frank, what are you doing in the evening? Pardon? Are you doing anything to make yourself, a better employee or, be able to get a better job? Like what business is that of mine? Because I'm not gathering it because I may have to let you go, because I don't have that in mind yet. COVID-19 hasn't happened yet, so I haven't had to reduce my workforce. So I'm going to collect information, personal information about you and what you're doing after hours. Totally inappropriate. And yet if I don't have that information when I let you go, how do I know what you've done and what you haven't done? So it's just, I think it's an inappropriate decision. Not only is it inappropriate, but what did they do? Well, they gave her 2 more weeks' pay. So I think they said she was deserving 8, and they were going to give her 10 or something, and the Court of Appeal said, well, let's give her 12. So 2 weeks extra pay, and they changed the whole landscape as far as dismissing employees go. Incredibly dangerous case, because we no longer know how that's going to impact us, except that we should in some way find out if the employee that we are sacking has upgraded their skills. Tough for the employee, but that's where it is. Now, the only good thing is it has not been used as precedent in subsequent cases on that point, and it is it may be confined to the public service, okay, as opposed to the private enterprise. Okay, we're going to do one more slide, and then we'll stop here, and I'll make another video for the next part of the chapter. The next slide is 141, and it talks about the things that you should look at if you are going to let someone go. You're not firing them for cause here. This is just employees that you don't need. And in a, I can barely read it. Let's see, a 1960 case. Hold on one sec. 1960 case of Bardell versus Globe and Mail. The judge itemized the things that you should take into consideration when you're trying to let someone go, and they might be required to additional pay in lieu of notice. So you look at the length of employment, okay, that's fine. You look at the Employment Standards Act, they've been here for 7 years, they get 7 weeks, okay? And then you look at the character of their employment. Oh, wait, they are managers. So they've been here for 7 years, so they need 7 months, okay? Then you look at the age of the employee. Okay, if you're going to get rid of an older person, they may require additional pay in lieu of notice because it might be harder for them to get a job. I mean, if I for some reason quit and then applied to another university to be a professor there, and I've been getting a high salary here because I have seniority, and I come up against a candidate that's right out of university, and you can pay them far less than me, you're going to hire them, not me, okay? Because my expectations will be higher. So you have to look at the age of the employee. Then you look at the education and training. This goes into the buyer's case. And then you look at the experience of the employee. How many years experience have they got with your company? How many jobs have they done? And then you look for availability of similar employment. So you have to take those things into consideration on top of just the Employment Standards Act. And the judge got to the end and said, and this list is not exhaustive. What's that mean? Well, that means that other things can happen. Because at the very time that this judge in Ontario was making this decision, the Supreme Court of Canada case was for Lazarowitz was going forward. So what the judge here was saying, I don't know what that decision is going to be, but it may be that you have to look at how long someone has been employed at their previous job as well as their current job. Okay, and then there's the Wallace case, which came after that, and says if there's bad faith, then you have to take that into account too. So this is the leading case, Bardell, plus Lazarowitz, plus Wallace, plus Beyer. Okay, although Beyer can figure into that, and that's probably how the court in the Court of Appeal figured it out. All right, that's enough for now, and we'll come back and complete this chapter in the next video.